Welcome to this video on the mapping of the Digital Personal Data Protection Act of 2023 to the DPDP Rules of 2025. This provides a detailed mapping of each section and subsection of the Act to the relevant rules and schedules. As discussed in the Part 1 of the video on raw reading of the DPDP Act 2023, it is organized into 9 chapters. These chapters cover various aspects, including preliminary provisions, obligations of data fiduciaries, and the rights of data principals. They also detail special provisions, the Data Protection Board of India, and penalties and adjudication. As discussed in the Part 1 of the video on raw reading of the DPDP Rules 2025, it consists of 23 rules. These rules provide specifics on areas such as definitions, notices, consent, data processing safeguards, data transfer, and the operational aspects of the Data Protection Board. In addition to the rules, there are 9 schedules that provide detailed standards and conditions. These schedules cover aspects like the registration of consent managers, standards for state processing of personal data, and terms for the appointment of the chairperson and members of the board. The core lawful purpose test in Section 4, subsection 1 and 2 of the Act is implemented through Rules 3, 4, and 5 of the DPDP Rules. This involves the notice and consent architecture, the consent manager framework, and rules for state processing. Section 5, subsection 1 to 3 of the Act addresses the notice requirement, which is operationalized by Rule 3.1a to 3.1c of the rules. Rule 3 mandates a standalone notice in plain language, stating data and purpose, and including means for consent withdrawal and exercising rights. Consent validity and withdrawal are covered by Section 6, subsection 1 to 6 of the Act. Rule 3 and Rule 4 of the rules, especially 3.1, detail the consent flow, ensuring it is free, specific, informed, and unambiguous. Rule 4 sets the framework for a registered consent manager. The process for consent through a consent manager and registration is addressed in Section 6, subsection 7 to 9 of the Act. This is directly implemented by Rule 4.1 to 4.5 and the first schedule, which outlines registration conditions and obligations. Section 6, subsection 10 of the Act sets the burden of proof for valid notice or consent. The rules, specifically Rule 3 and Rule 4, provide the prescribed notice form and the consent manager infrastructure used by a fiduciary to prove compliance. Section 7, subsection A of the Act concerns the voluntary provision and use of data. This is a direct statute, meaning there is no dedicated rule text in the 2025 rules beyond the general notice and consent architecture provided elsewhere. The Act itself governs this use. The processing of data for state subsidies, benefits, services, or permits under Section 7, subsection B of the Act is governed by Rule 5.1 and 5.2 and the second schedule. Rule 5 clarifies this processing must adhere to the second schedule standards and defines under law, under policy, and using public funds. Section 7, subsection C to I, addresses other legitimate uses of data. These uses are defined directly in the Act itself. There is no separate rule text to expand on these uses in the DPDP Rules 2025. Fiduciary responsibility and processor contracts are covered by Section 8, subsection 1 and 2 of the Act. Rules 6.1f and 6.1g, along with 6.1a to 6.1e, sets the requirements for reasonable safeguards, including technical and organizational controls, and contract clauses with processors. Section 8, subsection 3 mandates completeness, accuracy, and consistency before data decisions or sharing. Rule 6.1.d specifically requires reasonable efforts to ensure data quality when processing could affect the data principal or if the data is shared with another fiduciary. Technical and security safeguards, as per Section 8, subsection 4 and 5 of the Act, are detailed in Rule 6.1a to 6.1g. This includes minimum safeguards such as encryption, access controls, logging, backups, and retention of logs for 1 year, alongside process or contract protections. Section 8, subsection 6 of the Act requires a breach notice to the board and affected principals. Rule 7 sets the content for this notification, including an immediate description and a fuller 72-hour update to the board. The erasure of data after consent withdrawal or purpose ends, as per Section 8, subsection 7 of the Act, is governed by Rule 8.1 and 8.2. This rule sets the no longer served timing mechanism and requires 48-hour advance intimation before deletion. Section 8, subsection 8 addresses the deemed cessation of purpose after inactivity. Rule 8 uses the third schedule time periods to determine when a purpose is considered no longer served for specified classes of fiduciaries. Section 8, subsection 9 mandates publishing contact information. Rule 9 requires the publication of the data protection officers or other responsible contact details on the website or app and in rights-related responses. The grievance redressal mechanism is covered by Section 8, subsection 10. Rule 14.3 requires a grievance system to be published and states that the mechanism must be supported by appropriate technical and organizational measures. Moving to children and significant data fiduciary rules, Section 9, subsection 1 of the Act requires verifiable consent for a child or person with a disability. Rules 10 and 11 detail the mechanics for verifiable parental consent and lawful guardian verification, respectively. Section 9, subsection 2 prohibits detrimental processing to child welfare. The rules do not provide separate text here, meaning the prohibition remains directly operative in the Act. Section 9, subsection 3 restricts tracking, behavioral monitoring, or targeted ads for children. The prohibition is in the Act, but Rule 12 and the Fourth Schedule create narrow exemptions for listed classes and purposes. Section 9, subsection 4 allows for class or purpose exemptions from 9 subsections 1 and 3. Rule 12 and Parts A and B of the Fourth Schedule list specific exempt classes, like certain healthcare, and exempt purposes, such as legal duties and email-only accounts. Section 9, subsection 5 authorizes a future age-based exemption notification. The current 2025 rules do not separately operationalize an age exemption regime. Section 10, subsection 1 to subsection 2C.3 outlines SDF duties, including DPIA and audits. Rule 13.1 to 13.3 details these requirements, mandating annual DPIA and audit, disclosure to the board, and due diligence on technical measures. Section 10, subsection 2.C.3 covers other SDF measures. Rule 13.4 and 13.5 add the India-only processing restriction for specified personal data and defines the government committee for that designation. Now let's examine the rights of data principals. Section 11, subsection 1, covers the right to access information. Rule 14.1 and 14.2 require fiduciaries to publish how requests can be made and any necessary identifier for the data principal. Section 11, subsection 2, addresses exemptions for law enforcement-style requests. This exclusion remains directly in the Act and is not restated in the rules. Section 12, subsections 1 to 3 deals with correction, completion, updating, and erasure of data. Rule 14.2 handles the request channel, while Rule 8 controls the timing for data erasure once the specified purpose is no longer served. Section 13, subsection 1 to 3 of the Act addresses the grievance redressal mechanism. Rule 14.3 sets the published grievance system and requires technical and organizational measures to respond within the prescribed period. Nomination rights under Section 14, subsections 1 and 2 of the Act are detailed in Rule 14.4 and 14.5. Rule 14 allows nomination using the means and particulars required by the fiduciary and defines the identifier for this purpose. The duties of the data principal are outlined in Section 15, subsection A to subsection E of the Act. The 2025 rules do not contain a separate rule for these duties. Breach exposure is covered by the Act's penalty schedule. Moving to cross-border transfers and exemptions, Section 16, subsections 1 and 2 of the Act restricts cross-border data transfers. Rule 15 allows cross-border transfer subject to specific requirements from the central government. Section 17, subsection 1 of the Act outlines ordinary exemptions. These exemptions remain directly in the Act, and there are no complementary provisions in the rules. State or security exemptions under Section 17, subsection 2A of the Act are supported by the 7th Schedule for Rule 23 and Rule 8.3. The schedule identifies state and security-related purposes and authorized persons for information calls and retention. Section 17, subsection 2.b of the Act covers exemptions for research, archiving, and statistical processing. This is mapped to Rule 16 and the 2nd Schedule of the rules. Startup and small fiduciary-style exemptions under Section 17, subsection 3 of the Act are direct statutes and do not have a separate rule text in the 2025 rules. Section 17, subsection 4 concerns state processing carve-outs from Sections 8, subsection 7, and Section 12, subsections 3 and 2. Rule 5 and the 2nd Schedule supply the processing standards for state or instrumentality use cases. Next, we cover the board, appeal, and information powers. Section 18 of the Act establishes the Data Protection Board. Rules 17 to 21 detail the appointment framework, salary, service, procedure, and staffing of the board. The manner of appointment under Section 19, subsection 2 of the Act is prescribed by Rule 17. This rule outlines the operationalization of appointments through a search-cum-selection committee. Section 20, subsection 1 addresses the salary, allowances, and terms for board members. Rule 18 and the 5th Schedule set these service conditions. Disqualification, resignation, and vacancy of board members under Sections 21 and 22 of the Act are mostly direct statutes without a full parallel rule text in the 2025 rules. Section 23 of the Act addresses the proceedings of the board. Rule 19 prescribes meeting procedures, including circulation, authentication, and inquiry timelines. Rule 20 designates the board as a digital office. Section 24 of the DPDP Act 2023 addresses officers and employees. This corresponds to Rule 21 and the 6th Schedule of the rules, governing staffing and service conditions. Sections 27 and 28 of the Act deal with the powers and procedure of the board. This is supported by Rule 19.9 and Rule 20, implementing a digital by design procedure through digital office and techno-legal provisions. Section 29 of the Act addresses the appeal process to the appellate tribunal. Rule 22 implements this by requiring appeals to be filed in digital form, as determined by the tribunal. The provisions for alternate dispute resolution and voluntary undertakings are found in Sections 31 and 32 of the DPDP Act. It's noted that there is no dedicated rule text for this in the 2025 rules. Section 36 grants the power to call for information, supported by Rule 23 and the 7th Schedule. Rule 23 allows the central government to require information for specified purposes and restrict disclosure based on sovereignty or security concerns. Section 33 of the Act introduces a penalty schedule for breaches. It covers various violations, including failure to take reasonable security safeguards, breaches related to notice, child obligations, and voluntary undertakings. First Schedule, Part A of the DPDP Rules 2025 details conditions for registering a consent manager. These requirements include Indian incorporation, sound management, capacity, and interoperable platform certification, aligning with Rule 4 and Section 6, subsection 8 and 9 of the Act. First Schedule, Part B, outlines consent manager obligations. These include enabling consent, ensuring interoperability and safeguards, logging, grievance handling, audits, and avoiding conflict-style terms, as per Rule 4 and Section 6, subsection 8. The second schedule, linked to Rule 5 and Rule 16, sets standards for state or instrumentality processing under Section 7, subsection B. It also addresses research, archiving, and statistical processing under Section 17, subsection 2.b. The third schedule, referencing Rule 8.1, specifies the no longer being served time periods for specified purpose data retention or erasure. This is the trigger for deemed cessation under Rule 8. Fourth schedule, Part A, related to Rule 12 and Section 9, subsection 4, details child processing exemptions. These apply to specified fiduciary classes, specifically healthcare, education, creches, and child transport services. Fourth schedule, Part B, also linked to Rule 12 and Section 9, subsection 4, outlines child processing exemptions for specific purposes. Examples include legal duties, subsidy or service delivery, email-only account creation, and child safety tracking. The fifth schedule of the DPDP Rules 2025 aligns with Rule 18 and Section 20, subsection 1 of the Act. It addresses the salary, allowances, and service conditions for the chairperson and members of the Data Protection Board. The sixth schedule, corresponding to Rule 21.2 and Section 24, covers the terms and conditions of appointment and service for officers and employees of the board. The seventh schedule, linked to Rule 23.1 and Rule 8.3, specifies the purposes and authorized persons for governmental information calls. It also details the related purposes for the one-year retention of logs or data under Rule 8.3. If you are interested in trying out the DPDP Act provisions, you can use the Consent Manager Simulation Portal at myconsentmanager.co.in to test your integrations as a data fiduciary or data principal. We recommend the CalPI Quiz app, available on the Google Play Store, to test your knowledge of cybersecurity, the DPDP Act, and other important topics. The app offers various levels of difficulty and interactive assessments to improve your awareness. Thank you for watching this video relating to the mapping of DPDP Act and DPDP Rules. Hope you now know more about their relationships. This was the 29th video in this series, released by DPDPAmentor.in. Please visit our YouTube channel, DPDPA Mentor, as well as our website, DPDPAmentor.in, regularly to check out other informative resources. Wishing you a successful DPDP Act implementation.